This is Nathan Chapman at the University of Georgia School of Law, and I am an associate professor here, and I'm delighted to have as a guest on our sidebar series today, Steve Sachs, who is a professor of law at Duke University School of Law.
Good to be with you.
Thank you, Steve. And today is April 1st, but this is not a hoax.
As far as we know.
This is the real deal, as far as you know. So, Steve, thanks very much for being here today. Steve is with us in our faculty today presenting a paper that is tentatively titled The Official Story. And the paper is not publicly available yet. And so many of the ideas we'll be discussing with respect to the paper today are, again, tentative and stuff that he's going to continue to work out with his co-author, Will Baude, who's at the University of Chicago School of Law.
And who has not had an opportunity to pre-clear all the statements made here today, so don't hold him responsible. Indeed, all of this is subject to future revision and thinking better of it.
Great. Well, thanks, Steve, and hopefully we'll have a chance to continue to think better of it together today. So the official story. What is the official story, and why do we need to know about it?
So one thing that we've noticed in American legal practice is that there seems to be a difference between the official explanation of what the law is and where it comes from and the rules themselves. So the official rhetoric of the legal system, the orthodox mode of justification, is largely originalist in nature. People cite the original Constitution, they talk about what rules the framers laid down, and so on and so forth. But in fact, we see lots of rules that seem very difficult to trace to actual founding era law that are applied in practice every day. And so one question that this has presented to us is, what do you make of this? What does that mean for American law? Can one conclude anything from the way that judges and lawyers and other people feel the need to explain themselves? Or is that just sort of superstructure? Is that just sort of an illusion that we really ought to cast off if we're trying to figure out what the actual law is? So this project is part of a larger inquiry into that idea and trying to get a sense of what American law really is and what relation it bears to the law of the founding.
Great. Can you give us an example of something where the original story is in conflict with the way the courts are actually operating on a day-to-day basis?
Sure. So I think one example would be the Tidewater rule. Can a citizen of the District of Columbia sue in diversity? There was an earlier case where Chief Justice Marshall said, no, you have to be citizen of a state and citizen of a different state. So D.C. is not a state. We had a very split opinion by the Supreme Court more recently saying, no, this is okay. We have a statute saying this is okay. If you go to court as a citizen of D.C. and want to sue someone from Virginia for more than $75,000, you'll be let in. You'll be allowed to do that. So in everyday practice, if you're a lawyer in the office telling your client what to do, you'd say, yes, American law allows you to bring these suits, but the reasons why American law allows you to bring these suits are somewhat obscure, and the split opinion in Tidewater, all of the justices seem to feel some need to ground this, not in the idea that, oh, of course this makes sense, of course it would make everything much easier if they could do this, but rather in particular sources from the founding, particular clauses, Congress's power over the District of Columbia, and so on. And so that might be an example where the official mode of reasoning, the sorts of arguments you're supposed to make, don't seem in the end to justify the result. And yet we feel like the result is a good statement of American law. When you're teaching CivPro, you don't tell students, no, you can't go to court in diversity if you're a citizen of D.C.
Okay. So should the court just overrule the Tidewater decision?
Well, perhaps it should. I think part of what we're trying to get at is a sense that a lot of people have in the academy that maybe the answer is no. Maybe what the Supreme Court says really is the law of the land. Maybe there is no legal justification to depart from our long-established practices, that one can't go back to some earlier time, or one can't look at the rhetoric and the rationale and have that trump the actual outcomes courts are applying every day. Our intuition is somewhat different, that one does have a leg on which to stand, as Richard Fallon once put it, for criticizing current doctrine if it seems inconsistent with the arguments that the legal system itself is making.
Okay. Now, what role does precedent play in the official story? Because I can imagine many lawyers responding to this objection saying, well, at some point, a decision like Tidewater simply becomes the law, even if it was, incorrect at the time it was made.
So I think it depends a lot on what kind of doctrine of precedent we have. If you look at how the Supreme Court handles precedent, it still seems to think that cases can be wrong the day that they're decided. It still seems to think that that can be sometimes a good ground for overturning a case, that the precedent doesn't really supplant the underlying rule so much as give us a reason not to apply it on a particular occasion. It's sort of more like res judicata, where we'd say, well, there's an actual fact of the matter about whether the light was green or red, and that's different from what a court said about it. But sometimes we have reason to follow what the court said about it and not the actual fact of the matter, but those reasons can also run out. There can be times when legally you do have to go back to the actual underlying fact of the matter. And so I think that one of the issues in our system is, does precedent really change the law? Does it set a new legal rule, which is the legal rule from here on out, or does it stand in for the law? Is it something that we use, but that doesn't replace the underlying sources of law?
Okay. Your example of the red or green light makes it sound like the decision in Tidewater was clearly wrong, right? It's a binary decision. It's empirically determinable, and the court simply called what was clearly a strike a ball.
To use a metaphor.
To use a metaphor that some people might use. But I think many people think of many constitutional questions as not quite like that, right? They're somewhat indeterminate, and they call for an exercise of prudential judgment or practical judgment. And should precedent play a different role in those cases?
So, again, it depends on one's theory of precedent. Caleb Nelson has an excellent article in which he argues that the founding era doctrine of precedent was focused on demonstrable errors in one could feel relatively confident that the court had made a mistake. Mm-hmm. In circumstances where you couldn't, your job as a judge was to, or judges, or indeed anyone else, was to apply pre-existing law. And if you couldn't feel sure of what that was, you had a precedent on the table, you should use that. But if you could feel relatively confident that you knew what it was, you would apply the correct law and not the law that some court had, in your view, clearly erroneously found. It's more of an epistemic question mm-hmm. than it is a question about the substance of the law. Okay.
So I want to bring us back to the core of this very interesting paper that you're presenting today. And it is an engagement, a really rich engagement with current questions in the field of jurisprudential positivism. Can you explain positivism in a nutshell and exactly how your paper is an intervention in some conversations there?
Sure thing. So in a nutshell, positivism is the view that law is grounded on social facts. Law is something that societies do. Different societies do it different ways. And if you want to know what the law is in a particular society, you have to look and see what the people in that society do. That it's not necessarily something that depends on what's actually morally correct, that you can have societies with really bad law, where the law in their society requires lots of terrible things or forbids lots of good things. It's just a question of what that society does. For our purposes, the thing that makes this interesting is, what do you do when you've got multiple practices at the same time? You might have a practice of what's done on the ground, what's seen as normal, what's seen as acceptable, and at the same time you have a practice of an orthodox mode of justification, what kind of arguments you're allowed to make, what kind of arguments are seen as good legal arguments of the kind that are accepted in this legal system. And sometimes those two can come apart, where you have a situation where the best legal arguments don't seem to track the results that legal officials are reaching on the ground. One leading theory in this field of positivism is that of H.L.A. Hart, whose view has been summarized, although it may not be entirely easy to cabin, as holding that the law depends on social rules that are accepted by some legal community, most prominently by the officials of that community. And this paper is really trying to figure out what that means and what that ought to mean, what counts as acceptance and who counts as part of the legal community, whose practices, beliefs, activities end up determining the law.
So one might expect, Steve, that a theory of authority might account for the relative or the relevant public or the relevant community that counts for purposes of determining what the secondary rules are, the rules of recognition, as Hart would put it. But Hart kind of notoriously doesn't have much of a theory of authority. And so how does that intersect with constitutional law in the United States, where at least the official story has always been that the people are the source of political authority, and what they authorize is legitimate law, and that's how you can distinguish between legitimate and illegitimate. Is that in tension with a pure positivist theory, or is that reinforce your account?
So I don't think it's necessarily in tension. One thing that I find interesting is that there are a whole bunch of different theories of authority in American law. There's a sort of hagiographic, the founders were extremely wise people, and it's sort of, filial piety. These are they believe this, and therefore it's our law. There's a popular sovereignty view that the people adopted the Constitution, the people have adopted various amendments, and so that's why it's our law. And there's also a more straightforward, I think, sort of anti-positivist view that these rules in particular are just, and so that's why they're our law. This is what is fair and appropriate. Our view doesn't necessarily, to the extent that I can speak for Will, our view doesn't necessarily say that any of these are wrong. It may well be that these rules are just. It may well be that the framers were wise people. But I think that it doesn't quite capture the American practice to look at it that way. We don't follow, for example, the Telecommunications Act in 1996 because we think that Newt Gingrich and his colleagues in Congress were so wise that therefore we must do so, or that it really necessarily speaks for the people in its regulation of telecom carriers. We think that it's part of some bigger, more complicated legal system that has certain entities like Congress that can change the rules in certain ways. And in that sense, it's more dependent on broader kinds of rules. It doesn't depend on a single authority that is trusted to produce good law, although we may believe that that's the case. You could believe that what Congress enacts as law because you think it's democratic or because you think they're likely to do good things, but the rules of the game as they stand clearly involve Congress making law, even in cases where it isn't all that democratic, even in cases where it isn't all that wise.
Sure. I want to push you a little bit more on the sort of popular sovereignty side, because as I see it, it has the best case for being described as an important component of the official story. Right? The preamble of the Constitution says it's we the people who are giving life to this and force to it. In virtually every homage that justices give to the founding era, they don't give an homage to Madison and Hamilton as, quote unquote, the great men. They give an homage to this is the law that the people created, and the people bound themselves to it and to a form of amendment process, et cetera, et cetera. So if it is the case that popular sovereignty is part of the official story, does that have an implication for who the appropriate public is for determining the content of the law?
So let me back up for a sec. So one of the reasons why Hart paid a lot of attention to officials was his view that most of the time, most people don't know a whole lot about the law and can't be thought of as endorsing it in all of its complexity. Leslie Green has argued that lots of people in California don't know that there's a California Constitution, so how can we say that it's the man in the street who really determines what the law is. And, all lawyers know that lots of people have very unusual beliefs about what is part of the law and what isn't. That in that sense,
including some lawyers.
including some lawyers, law in that sense seems to be some sort of elite practice. So it's in tension with this idea of popular acceptance, popular sovereignty. And one of the points that we try and make in this very tentative draft paper is that, in fact, the officials are not the only game in town. If you think about a game of baseball, you can have umpires who are making bad calls. You can have them even potentially conspiring to fix a game. But we don't think that by doing that, they're changing the rules of baseball. The players are also involved. And even if they don't understand every jot and tittle of the infield fly rule, there's some story about how the system that the players do accept is connected to these more elite, more abstract rules. If we're trying to figure out what the rules of baseball are, at least part of that depends on, well, what do the players think and who do the players trust? Who do they take as experts? We see that in lots of different social domains. So if you're asking, what's the socially accepted form of address for an ambassador or for a cardinal, that it's your eminence, that's not something that people know if you ask them on the street. But if you ask, where should I look to find this out? You talk to a bunch of people and they might Google it. They might go to Wikipedia. They might go to Ann Landers. There'd be some agreed upon way of solving these questions, that we sort of outsource certain kinds of social rules to particular people, particular experts in the field. You see that even in law. If somebody comes in with an admiralty law question or some very complicated question of tax law, you might be a lawyer and say, well, I don't know, but ask that guy. That's the tax guy. He knows what the answer is. And in that sense, the social practice that we all accept, that's part of our social practice, can be defined in very large part by the beliefs of recognized experts. But that's different, I think, than having it defined by the officials who are actually using the power in the system. You could have a system where the officials don't know very much. The average police officer, perhaps, knows only a very small corner of the law, but they recognize similar experts that everyone else does, and they're looking for the same books. And in that sense, the social practice is unified, and it's unified, maybe in a way that law professors are too quick to applaud, but it's unified in a way that depends a lot on who is thought to have expert knowledge about the system. If that picture is right.
It is curious that this gives certain law professors like a leg up over, for instance, the Supreme Court, in identifying and saying what the law is.
Indeed, but we do that all the time. So, you see articles that say, wow, the Supreme Court just messed up this trust law case. They don't know anything about trust law. And that statement is coherent because we understand, yes, these 9 generalists on the Supreme Court who are trying to get at a practice of trust law that, the invisible college of trust experts and practitioners, in some sense, knows better than they do. Certainly everyone who's ever clerked has had the experience of thinking that there are vast seas of law that they just don't know and need to find out, and they're terrified about getting it wrong. The idea of that being at all possible suggests that maybe it's not just officials that we should be looking at, but sort of who other people take as knowing stuff about this social practice. And that this is not popular sovereignty in the sense of, we take a vote and raise hands and whatever gets 50% plus 1 is the agreed upon solution, but there is a sense that it's shared among all of the people who actually buy into the system. If you buy into, English grammar, then you might be looking to Strunk and White or something like that. If you buy into American law, you might be looking to Prosser and Keaton on torts or something to define what counts as the agreed upon rule.
So I take your point that the American people, no less than law professors and other wonks, have an ability and a language for criticizing Supreme Court decisions as being poorly reasoned, wrongly decided. Of course, the justices themselves have those abilities and do it vigorously sometimes in dissenting opinions. But I don't know that it is coherent to say what the Supreme Court just decided is not law.
Well, again, to quote Gail Nelson, like every American lawyer would understand a statement of the form, the Constitution plainly requires X, but the Supreme Court has misread it to say Y, and the Supreme Court is not about to overturn that statement. We do that all the time. We do that when we say that an umpire has made a bad call, again, to use an analogy, and even if their call is not later reversed by the commissioner, even if there's no getting out of it in that game, you can still say, well, there are rules, and those rules are distinct from their application on this particular occasion. Now, if everyone all the way down said, yes, that's absolutely right, we're going with this now, this is what we think, in that sense, it would be hard to say that they're all wrong about what their law is, in the way that it's hard to say that, everyone in America is wrong about what English is, or something like that. It would be, there are limits to prescriptivism, but it is still possible, so long as people recognize particular sources, particular, fields of expertise. It is possible for any individual institution to get it wrong on a particular occasion.
Sure. So maybe we've argued ourselves to a point where what I would describe the situation being is that there is a sort of tradition and mode of constitutional argumentation that is widely accepted and well known, although it includes, different people would emphasize different sources of authority probably with respect to that argumentation. And it is always sort of a loaded weapon lying around for someone to pick up and challenge any constitutional decision, whether by the highest or the pettiest official. But it is a loaded weapon aimed at the law, not a loaded weapon, or not the law at which the higher petty official's decision is a loaded weapon aimed at. So, but to the extent this is semantics versus the extent to which this is an important point for positivist theory, I don't really know, to be honest.
I think it depends a lot on what we think of as appropriate grounds for criticism. So you could imagine writing a standardized college entrance exam and having the grader mark something down as a grammar error. Mm-hmm. And you can imagine saying, like, well, look, if what I want is to get into college, I just have to fit all of the grader's pet peeves. Ultimately, that's what I want. And likewise, if you're going to court, I've just got to persuade Justice X. I just need to get to 5.
Steve, everyone knows that to go to college, you just have to bribe the right person.
Well, that may be true. But that seems different from saying that, literally the grader can do no wrong, or that the Supreme Court can do no wrong. There are systems that have people in them who can do no wrong. My empirical look at American law is not that's how our system works. It may well be that if the Supreme Court is against you, you might have a hard time on appeal, but that doesn't mean that they are incapable of error, that the standards that we recognize take their word as law in all cases. We can identify a distinction between what this particular person does and what the prevailing standard is that would be applied. And so for that reason, I don't see this so much as a loaded weapon, though it can be used for that, it can be used as a ground for criticism. But the reason it can be used as a ground for criticism is because we're committed to some extent to a standard where one ought to apply rules like this. If we didn't have that commitment, then the gun would just fire blanks.
Okay. This has been a rich discussion. Thank you for your time. I want to close, I think, by working through, if you're amenable to it, working through the Obergefell decision as a kind of example or something that illustrates the dynamics we're talking about. And I'll lay out what I take the Obergefell decision to be doing in a way that is meaningful for this conversation. And if you read Obergefell differently than I do on that score, absolutely feel free to fight the hypo.
Sure thing.
Okay. So Obergefell is the decision in which the Supreme Court held that under the Due Process Clause and the Equal Protection Clauses of the 14th Amendment, the states may not prevent or may not decline to recognize the marriage of same-sex couples. So it sort of creates a fundamental right to marriage for same-sex couples. Now, the majority wrote an opinion authored by Justice Kennedy, and Justice Kennedy was pretty straightforward, if I remember, in disclaiming reliance on any sort of original history. And he opted to emphasize mostly the due process clause and acknowledge that the history even of the 14th Amendment due process clause and subsequent cases didn't provide a whole lot of support for his conclusion. As authority, he relied on a couple of different things. One is a decision saying that states could not prevent people of different races from marrying one another, Loving versus Virginia case, and separately sort of evolved moral norms in American society that were reflected in social movements to authorize same-sex marriage. Okay, so that, as I understand it, is Kennedy's basic position. The dissenters argued that those were not sufficient authorities on which to base the court's decision. And so now you've got the result. That's the case. Is it the law? If it is, why? Now, I would submit as further part of my hypo here that many law professors and legal scholars would have accepted the court's opinion and have made the case that there may be far more robust equal protection grounds, both in history and in precedent, for the same conclusion, but the court did not rely on those arguments, originalist and otherwise. The people of the United States, however, it seems to me, at least by now, have largely embraced the decision and don't care whether or not it was based on the original understanding of the Equal Protection Clause, the original understanding of the Due Process Clause. They think that it was just. So why is the Obergefell decision the law or not the law?
So I think that Obergefell is clearly, I think everyone, both those who agree with or disagree with the decision, is clearly the law for the parties. Okay. It is clearly the law for purposes of vertical precedent. If the Fourth Circuit were tomorrow to say, not Obergefell, they would be committing some kind of legal error, at least under the State Oil rule. One really interesting fact about Obergefell, and I was trying just now to get the original language up, but having difficulty finding it, is that even in a case where Justice Kennedy was sort of downplaying the relevance of certain aspects of founding era history, here the founding period being that of the 14th Amendment, the time of its enactment, made the argument that the generation that framed the 14th Amendment conferred on subsequent generations a charter that protected liberty in forms that the later generations would come to know. I'm butchering the exact language,
Sure,
but
yeah.
that's the nature of the argument. And what I find very interesting is that was necessary. You could not write an opinion. It would not be seen as a conventional orthodox legal opinion that just said the people who wrote the 14th Amendment were terrible people and they did not know what is actually just, and we do know what is actually just, and therefore we should do this. That was not the reasoning of the opinion. The reasoning of the opinion was they protected liberties of a certain category, even liberties that they weren't currently thinking of. And if we understand that the liberties extend further than they thought, then it is appropriate for us to apply their guarantee to the facts as we see them. Mm-hmm. This is essentially applying, a rule to fact. Now, that can be challenged. Either one could disagree with the decision on its substance day as to what sort of liberties are of the right kind or of the right importance, or one could say, no, in fact, that's not what the 14th Amendment was doing. It did not guarantee a certain sort of universe of liberties as we would understand it. It guaranteed some more limited set or a set defined in a different way. And in that sense, the argument of Obergefell is vulnerable to historical refutation. It is possible that one would say, look, you made this argument, you needed to make this argument. It is conceivable that one could disagree with it on the following ground. That's not to say that it is actually refuted. I'm not making a historical argument one way or another. But the form of argument is one that actually takes history quite seriously, even at the same time that it suggests that the particular beliefs of the generation that framed the 14th Amendment might not be legally actionable. That mode of justification is distinct from the question whether people think it's right or even whether people think it's fundamentally right, that people today think that there's something fundamentally wrong with a legal regime that does not guarantee this kind of right to same-sex couples. And so I think that one way to test whether this is part of our legal norms is to say, well, could one write an opinion just saying, this is how our generation thinks about what's just, period? I think the answer to that is no. I think, a lawyer going into court would not think that that was compatible with the norms of legal practice. That isn't how you would frame the argument even to your client in your office. There is still the requirement that you explain how this thing is connected to the 14th Amendment that was actually adopted. And that argument can be correct or it can be incorrect, but there's a standard there that has to be met that's connected to the early history. And the mechanism of that connection is the official story, the system of justification, the kinds of arguments that are or not seen as proper legal arguments.
Okay. Thank you very much again for your time, Steve. It's been a delight. Looking forward to your presentation to the faculty later today, and again, grateful.
Thank you.